Hello students, I am Marjina Sultana, an assistant professor from Interpersonal Law College, Greater Noida. Today we will study primary sources of Muslim law. Ijma is the consensus of the opinion of the jurist, and it is the third source of law in Islam in point of time and importance. Ijma has been defined by Sir Abdul Rahim as an agreement of the jurist among the followers of the Prophet Muhammad, peace be upon him, in a particular age on a particular question of law. Wilson defines it as occurrence, meaning propositions shown to have been accepted as indisputable under the first four rightly directed caliphs or in the time of the companions and of the generation immediately succeeding them. So according to the Wilson, the ijma or the consensus of the opinion of the jurist is indisputable if that occurred under the first four rightly guided caliphs. Khalifa, known as Khalifa in Arabic. So, who were the first four rightly guided caliphs? The first one is Hadrat Abu Bakr Siddiq, second one is Umar, third one is Uthman ibn Affan, and the fourth one is Hadrat Ali. So, if it occurred under these rightly guided caliphs or in the time of the companions of the Prophet Muhammad, peace be upon him, and of the generation immediately succeeding them, then it is indisputable. So here talking about the, we can say, two generations. First one is of the companions of the Prophet Muhammad and of the generation, the next generation. So ijma includes the explanation, elucidations, and the decisions of the disciples of the Prophet Muhammad. And according to the classical theory, failing Quran and the traditions, that is hadith, the consensus of opinion amongst the companions of the Prophet is recognized as the best guide of law. So when a problem arose and it cannot be decided, which cannot be decided by reference to the Quran and the Hadith, then the Ijma provides is recognized as the best guide of law. So it is the third source of law in Islam. However, there is a great difference of opinion among the important Muslim jurists with regard to the requirements of a valid ijma. But there is a general agreement, or we can say consensus, that ijma of the companions of the Prophet should be invariably accepted. Some does not accept the ijma of the generation immediately succeeding them, but everyone, all, it is a general agreement that the ijma of the companions of the Prophet Muhammad, peace be upon him, will be accepted. The authority of ijma as a source of Muslim law is also founded on Quran and the Hadith. Quran in chapter number 4, verse number 59 says, O you who believe, obey God and obey the Prophet and those of you who are in authority. And if you have a dispute concerning any matter, refer it to God and the prophets. And the prophet, it means that we should obey the God and the messenger and the authority. When authority means Quran, Hadith, or the ijma. But if we disagree over anything, we should refer it to Allah and the messenger. This is, and there is also a hadith which says there can be no consensus on error or misguided behavior amongst my people. The society is ever changing, which requires new law and a new decision. So the principle of ijma was evolved to meet the ever changing needs of the society, to fulfill the needs of the society. So, so also with the march of the time, development of civilization and the expansion of the Islamic influence, numerous problems arose which could which could not be decided by the reference to only Quran and the Ahadith, the traditions of the Prophet Muhammad, peace be upon him. So the jurist mujtahids evoked the principle of ijma. Further, these laws are evoke the principle of ijma to provide the laws that are needed for the benefit of the community. The, the authority, this, the mujtahid has the authority to lay down laws because divine legislator has delegated power to lay down laws by the resolution of those men in the community who are competent in that behalf, on behalf of the divine legislator. So the mujtahids or jurists have the are competent to lay down laws for the benefit of the community. It's because of the belief that since the Muslim religion does not admit the possibility of further revelation after the death of the Prophet Muhammad, the peace be upon him, the principle of ijma is the only authority for legislation in the present Muslim systems. The definitions of ijma has got some essential ingredients of a valid ijma. The first ingredient is consensus. Consensus may be reached through three stages. The first stage is the people express their views. Secondly, discussion and debates takes place. And thirdly, the differences are dropped and they agree on one point. The second ingredient is the jurist. In every field of knowledge, only the opinions of the experts are admissible. Since the jurists are being the experts, therefore, only the opinions of the jurist are relevant for ijma. But there are two kinds of religious matter. One, which do not require any advanced knowledge for their recognition, such as the saying the prayers 5 times a day, keeping fast during the month of Ramadan, etc. So these matters do not call for any discrimination between the jurist and the general public. But there are others other matters which are beyond the reach of the competence of the public at large, which requires skilled opinions such as the rights of the marriage, saying rights, marital what to say, reciting rights of the marriage, the rules of divorce, the principles of sale, and the laws of inheritance. These matters requires expertise. It requires jurist. The third condition is jurist of a particular period. Obviously, it is not possible to have law laid down by ijma during the Prophet's lifetime. It is possible only after him. So, ijma of one age may be reversed by subsequent ijma on the same age. Similarly, ijma of one age may be superseded by ijma of a subsequent age. But the ijma arrived at by the companions is incapable of being reversed or superseded. So the ijma of companions is unchangeable. It cannot be changed. The fourth condition is jurist to be the Muslim. So the views of the jurist belonging to the non-Muslim communities are not admissible for ijma. The fifth condition is consensus on a religious matter. The religious matter may be of two kinds, points of fact and the points of law. If, for example, ijma on the matter that the text of the Quran, which is with us, is the same that was revealed to the Prophet Muhammad is ijma on the point of fact. It is a fact, but ijma on the matter that the government of the Muslims must have representative capacity and should run by consultation is ijma on point of law. There are three kinds of ijma. First is ijma of the companions of the Prophet Muhammad, peace be upon him. The second is ijma of the jurists, that is mujtahids, and the third is ijma of the people. Qiyas is the last primary source of Muslim law. Qiyas means reasoning by analogy from the first three sources, that is the Quran, the Sunnah, and the Ijma. In Qiyas, rules are deduced by the exercise of reason, applying reason on some text to be governed by the reason of the rule underlying it. Qiyas has been supported by a hadith of Prophet Muhammad, peace be upon him, which may be quoted here. When Muad was being sent, he was sent to Yemen, the Prophet asked him on what would base his decisions. Muad replied, I will judge them according to the book of God, that is, Quran. Prophet then asked, if the Quran does not give guidance to the purpose, Muad replied, then upon the usage of the Prophet. Prophet again asked, but if that also fails you, Muad replied, then I shall follow my own reasons. The Prophet raised his hands and said, praise indeed to God who guides the messenger of his Prophet in what he pleases. Here the Prophet Muhammad, peace be upon him, praised Allah for guiding Muad. So Qiyas may be defined as a process of deduction by which the law of the text is applied to the cases which, though not covered by the language, are governed by the reason of the text. Thus, it should be noted that Qiyas does not purport to create new law. It does not create new law, but merely apply old established principles to new circumstances. The Shias, that is the another sect of Muslim, do not accept Qiyas as a source of law because, according to the Shia, they are of the opinion that if law need to be enlarged, it must be by the Imam and no one else. But all the four schools of Sunni sect, accepted Qiyas as a valid source of law. And in fact, much of the Sunni law is evolved as a result of the recognition of this institution, Qiyas. According to Imam Abu Hanifa, by the by the process of Qiyas, the proposition is diverted towards the Quran and the Hadith. So, by using the Qiyas, analogical deductions, we are moving towards the Quran and Hadith, not away from it. Qiyas was upheld by the Prophet Muhammad, peace be upon him, both by precept and practice. Even in the period of Caliphate, that is, during the period of Khalifa, the validity of Qiyas was not questioned. The Prophet is also, it is reported to have said that, Prophet have said that, give your rulings in accordance with the provisions of the book and the Sunnah if such are available. If you do not find such provisions, have recourse to your opinion and interpretation. So, according to this hadith, our ruling should be based on the Quran and the Sunnah, if we do not find, if this is not available in the Quran and the Hadith, then we have to use our own reason, opinion, or interpretations. There are certain conditions for the validity of Qiyas. First, the original source from which the Qiyas is deducted must be capable of being extended. That is, it should not be of any spatial nature. So, in the deductive reasoning, it starts from the general to the specific, not from the specific to the general. So, in the deductive reasoning, it starts with a general idea and reaches a specific conclusion. So the original source should be, it must be of capable of being extended. The next one is the law of the text must not be such that its raison d'etre cannot be understood by human intelligence, nor must it be in the nature of an exception to general rule. So the law of the text from which the qiyas is to be deducted must be understandable by human intelligence, by applying human mind, and it should not be an exception to some general rule. It should be general. The third condition is the original order of the Quran or Hadith to which the process of qiyas is applied should not have been abrogated or repealed. The original order of the Quran or Hadith should be maintained. The fourth condition is the result of qiyas should not be inconsistent with any other verse of the Quran or any established sunnah. We know that Quran or the Hadith is more important source of Muslim law, so it cannot the qiyas, the result of qiyas or analogical deduction cannot be in contrary or inconsistent with the Quran or any established sunnah. The fifth condition is qiyas should be applied to ascertain a point of law and not to determine the meanings of words used. Why do we, what the purpose of analogical deduction is to ascertain, to determine a point of law, to determine a law in a particular new circumstances, but not to determine the meaning of the word used in the text. And the sixth condition is the deduction must not be such as to involve a change in the law embodied in the text. So, while doing deduction, analogical deduction, it should not change the original law embodied in the text. From this discussion, we can conclude that qiyas is a weak, it can be said that qiyas is a weak source of law, and the rules analogically deduced do not rank so high as authority as those laid down by the Quran and the Hadith or by the consensus of opinion. So its authority is not so high as that of the first three Quran, Hadith, and the IJMA. The reason is that with respect to analogical deductions, one cannot be certain that they are what the lawgiver intended because it is based on the individual reasoning. It may differ from the intent or the object of the original law, intention of the original law. So such deductions always rest upon the application of human reason, which are always liable to err, human errors, okay? But the law of God is not. We have discussed all the primary sources of Muslim law, that is, the first is Quran, second Hadith, third Ijma, and the fourth Qiyas. In the next video, we will do secondary source of Muslim law. Thank you.